Yes, so thank you so much for coming to episode 1 of ERN lecture series. My name is Tsubasa Shinohara, who is an assistant professor at the University of Tsukuba, Institute of Humanities and Social Sciences, and human rights officer at the Swiss Esports Federation. I will give you a lecture on esports governance and law. Does esports law exist today? This lecture lasts 40 to 60 minutes, and thus I cannot talk all topics for introduction to esports law. But I will describe how you should understand the esports society and who can regulate it. Please note that there is currently no established body of law specifically regulating the esports society. However, this lecture represents a fundamental step towards developing a legal framework for the esports society to mitigate potential legal risks. As such, esports law will fall significant importance in the future, making it a subject worth studying and understanding. This is the structure of my lecture today. The first, I will talk about what is esports law, and then I will describe the structure of esports society, and I try to categorize the esports title into the three different categorization. And then fourthly, I will talk about the crucial role of intellectual property law in the esports ecosystem, because intellectual property law is very important to be understood to understand the esports society and then how we will understand esports law as well. And then fifthly, esports publishers and esports competitions, and six esports federation and esports competition as well. And then next, I will talk about integrity issue in esports, but this topic will be dealt with by the other presenters in this lecture series. So that's why we'll talk about a really brief introduction to the integrity issues in esports. And then finally, I will describe dispute resolution in esports. The most contentious question is whether esports should be considered sports. But simply, the definition of esports remains highly controversial and unresolved topic. This lecture will not attempt to categorize esports as sports. This approach is adapted to avoid political conflicts that often arise between the esports sector and traditional sports sectors. While esports may not be considered traditional sports in the strict sense, one could argue they represent new sports. It is also worth noting that national, international, and supranational laws can and do apply to the esports society, much like they do in the realm of sports law. Sports law encompasses frameworks such as international sports law, European sports law, and national sports law, and it is likely that esports law will eventually include similar branches within its scope. However, due to the constraints of these 40 to 60 minutes lecture, these specific branches will not be covered in detail. Instead, the focus will remain on the fundamental aspects of esports law and its unique characteristics. So, what is esports law? To be honest, there is no specific or codified esports law. However, esports society has gradually developed and its global economic revenue has significantly increased. This growth has attracted business enterprises to enter the esports market. At the same time, gamers are now able to earn a living through various means, such as prize money from esports tournaments, live streaming on platforms like Twitch and YouTube, and sponsorship agreements with businesses. These developments necessitate the regulations of the conduct of esports stakeholders in accordance with the law. However, what is law? For non-legal students or the persons, it's really difficult to understand this topic. But this question is a profoundly philosophical question. To grasp the concept of law, one might refer to hard legal theory, but you don't know absolutely if you never studied the law. However, this lecture does not focus on the philosophy of law. I will refrain from delving into the details. Instead, I encourage you to consider what we mean the law in this context. Does law refer exclusively to national legislation? Can international law be recognized as law? Are self-regulations established by private entities also considered law? These questions are crucial for understanding what esports law truly entails and how it fits within broader legal frameworks. The answer is relatively simple. All can be recognized as law. This concept is known as legal pluralism, which acknowledges that multiple entities can create laws to regulate their own communities. From the perspective of legal positivism, self-regulation established by private entities may not be classified as law because they are not legislated by the state. However, in reality, our society includes various types of regulations and rules that govern different communities. For example, church law is a set of rules that specifically applies to the Christian community. While it does not apply to society as a whole, it functions as a special law within that community, binding all members who belong to it. Based on this understanding, esports law can be defined as a set of rules that specifically apply to the esports society, including all esports stakeholders. So, I will briefly give you an understanding of the structure of esports society. The esports society consists of multiple stakeholders, each of whom may establish their own rules. To clarify this complexity, this lecture will distinguish between esports society and esports communities. This distinction is important to understand the broader structure of esports governance and how various rules interact within this multifaceted ecosystem. The esports society encompasses all esports stakeholders, including esports publishers, esports federations, esports teams, sponsoring companies, and others. Among these, esports publishers are often regarded as dominant stakeholders due to their ownership of copyrights for esports titles. These copyrights grant publishers significant control, allowing them to prohibit the organization of esports competitions and even restrict access to their video games. This dynamic has led to the esports society being characterized as a fragmented structure, as there is no unified governing body overseeing the entire ecosystem. The influence of publishers' copyrights is a critical factor in understanding the complexities of challenges of esports law. In the context of sports law, not esports law, it is evident that sports governing bodies play a central role in regulating their respective sports communities. Notably, International Olympic Committee, IOC, exercise significant authority, power over recognized international sports federations, ensuring the enforcement of the Olympic Charter across their operations. Within the international federations, for instance, FIFA also have their own statutes and regulations and they can impose these regulations on the National Federation, National Football Federation. And then National Federation have to follow these regulations in order to keep the coherency of the regulations. This arrangement is often referred to as the hierarchical structure of sports governance. In contrast to this, esports society lacks such a unified hierarchical governance structure. Instead, regulations within the esports society is fragmented, with esports publishers exerting control over their own specific communities, primarily through the enforcement of copyright and self-regulations. So that's why, as I already mentioned earlier, there is no unified regulations, and unified actors can create common standard over all stakeholders within the esports society. So that's why it's really complicated to understand of esports law. And then, as I also said in the first section, there is no established body of law within the esports society. So let's move on to the categorizations of esports. This lecture will classify esports, titles esports, to provide a clear understanding of its structure. Esports can be categorized into the following groups. First, virtual sports. Second, sports video games. And third, traditional esports titles. This classification is essential for understanding the scope of esports as different stakeholders, such as game developers, tournament organizers, and sponsors, are involved in each category. By distinguishing these categories, we can better comprehend the dynamics and the governance of the esports society. Firstly, what are virtual sports? Virtual sports can be divided into two categories. First, VR sports. Second, VR esports. So the first, what are virtual sports? Virtual sports are based on augmented reality technology, which integrates digital information with the user's real environment in real time, and virtual reality technology, which creates an immersive artificial environment for players to engage in virtual sports and compete against others. In the context of video games, we usually use virtual reality technology to create virtual space to do the sports with the specific special equipment. So that's why we will not use the augmented reality technology for the video games. These technology can be used for the football stadium, for instance, in order to do the football referee system, some others, but the VR reality for the other things. VR sports are sports simulation video games played in an artificial virtual space, while VR esports involve esports games played using VR headsets and controllers, replacing traditional controllers like the keyboards and mice. The IOC has recognized Zwift, Gran Turismo 7, and Just Dance as official esports events in the Olympic esports series. If gamers wish to play VR sports, they must use specialized VR equipment that connect their physical movements and visual input to the virtual environment, as you can see on the photos. In contrast to this, VR esports involve competitive gaming in virtual environments using VR technology. So it means that additionally, in December 2023, the Asian Games esports demonstration events in the Hangzhou, China, showcased VR AR technologies as part of the events. This indicates that VR esports are gradually developing, and the industry should be monitored for further advancements and potential growth. So, virtual sports have recently emerged within the esports industries, as evidenced by the examples of ERN sports and esports tournaments already taking place. However, the widespread adoption of virtual sports will depend on advancement in technology and reductions in consumer cost, because it is really expensive to buy these virtual reality equipment. Therefore, it is important to monitor the ongoing development of this segment of the esports industry in future. Secondly, sports video games have long been popular in the esports society. Titles such as EA Sports, eFootball, NBA 2K are well-known examples. Gamers engage with these esports using traditional equipment like PCs, keyboards and mice, gaming consoles, or smartphones. This means that players do not need specialized equipment to participate in this type of esports. For instance, Electronic Arts, a prominent American esports publisher, produces EA Sports FC24. Konami, a Japanese video game company, produces eFootball. These examples are considered traditional esports titles, but this lecture categorizes them separately as they have a significant potential to be recognized as official esports events by the IOC due to their sports simulation nature. Finally, traditional esports titles are an integral part of esports society. This category includes fighting games such as Street Fighter and Super Smash Bros., lead time strategy games such as StarCraft, first-person shooter games, Call of Duty, Overwatch, Counter-Strike Global Offensive, multiplayer online battle arena games, League of Legends, Fortnite, Dota 2, digital collectible card games, Hearthstone, and Legends of Runeterra, if my pronunciation is correct. These categories feature in global esports tournaments organized by publishers and league organizers. However, it is important to note that International Olympic Committee did not include traditional esports titles as official events in the Olympic Virtual Series in 2021, due to the legal and practical barriers to their inclusion within the Olympic movement. So let's move on to the crucial role of intellectual property law in the esports ecosystem. Intellectual property law, particularly copyright law, is a central legal subject in esports law. This is because esports publishers typically hold copyright to their respective esports titles. For example, Riot Games own the copyright of League of Legends, ensuring that this title is protected under copyright law. Therefore, copyright law is crucial for the esports society as it grants publishers significant control over their games, including the ability to regulate their use in competitions, streaming, and other activities. In this lecture, I will briefly outline significance of copyright law and its impact on esports ecosystem. World Intellectual Property Organization, is called WIPO, defines copyright as the following. So copyright, or the author's right, is a legal term used to describe the rights that creators have over their literary artistic works. Works covered by copyright range from books, music, painting, sculpture, films, and computer programs, database, advertisements, maps, and technical drawings. Absolutely, video games may be included. They fall within this scope of the copyright. Furthermore, if you possess copyrights, you can exercise the following rights. So the economic rights, which allow the rights owner to derive financial reward from the use of their works by the others, and moral rights, which protect the non-economic interests of the author. Furthermore, the people explain the economic rights as follows. The economic rights owner of the work can prohibit or authorize reproduction in various forms, such as printed publication, sound recording, Its public performance, such as in playing a musical work, its recording, for example, in the form of compact disc or DVDs, its broadcasting by radio, cable, satellite, its translation into other languages, and its adaptation, such as novel into the film, screen, play. So, this is a basic understanding of the copyright law, and furthermore, it is important to know that copyright protection does not require legislation. It is automatically granted in the countries that have ratified the Berne Convention, which you can see in the PowerPoint. If you say the trademark, we need to register in order to protect this mark, and then in order to exclude the other competitors to use the same marks. So the trademark has the brand name and the power to gain the money. So that's why there is the legislation system. But for the copyright protection, does not need the legislation. That is the huge difference. Nevertheless, many countries offer voluntary registration system for works as well. Such system can be beneficial in resolving disputes over ownership or creation, and they can also facilitate financial transaction sales and assignments on transfer of rights. However, it is crucial to understand that copyright law vary across jurisdictions. Each country may have its own specific criteria for copyright protection, so it is essential to consult the relevant national legislation to understand the applicable rules and requirements. In the context of esports and video games, gaming companies enjoy the copyright protection for their works in each state. This grants them an exclusive right to prevent others from using their copyrighted content, effectively allowing them to exclude competitors within the video game industry. As a result, gaming companies hold significant power within the esports society, as their copyrights provide them with control over how their games are used in competitions, streamings, and other esports-related activities. This dominance establishes them as a key stakeholders in shaping the structure and dynamics of the esports ecosystem. Under the copyright protection, esports publishers can grant licenses to esports league organizers such as ESL Gaming and DreamHack, as well as esports federation like International Esports Federation and Global Esports Federation, allowing them to use specific esports titles for hosting tournaments. Additionally, publishers can independently organize their own esports tournaments based on their copyrights without requiring contracts or the partnership with other entities. If they want to have a sponsorship, they need to have the contract, but that is different issues. Moreover, esports publishers may permit live streaming gamers to use their products for showcasing their skills on platforms like Twitch and YouTube. These examples highlight that esports publishers hold exclusive right to decide how their intellectual property is utilized. This exclusivity enables them to strategically develop their own business and control the growth of the esports ecosystem through licensing agreements granted in the copyright law. So, I will try to see the esports publishers and the esports competitions. Generally, esports competition can be categorized into two types. So first, esports companies organize competitions, and second, esports federations organize competitions. I already mentioned this categorization in my article, which is published by the Gaming Law Review. So you can also refer to this article, but that is not open access. That is going to be really difficult for you to have access to. But here, I will provide a brief explanation of this first categorization. Esports companies, including esports publishers, esports event organizers, have organized various international esports competitions without involvement of esports federation. The esports publishers organize events such as Overwatch League, Call of Duty League organized by the Activision Blizzard, And League of Legends World Championships hosted by Riot Games. Furthermore, they may outsource their esports operations to esports event league organizers or third-party organizers. Thus, esports league organizers organized by the Intel Extreme Masters, ESL 1, ESL Pro League organized by the Electronic Sports Leagues, ESL, the Esports FIFA is already different right now because FIFA and Epic Games had the agreements. The EA has agreements. Electronic Arts have the agreements to resolve the contractual relationship, and then now Electronic Arts decided to organize their own event alone. So the Fortnite World Cup organized by the Epic Games and Esports Engine. The rules and regulations for this competition are established by the esports publishers and esports league organizers themselves. For instance, ESL publishes a rulebook that outlines how participants should play competitive video games before, during, and after the Intellectual Extreme Master competition. In these competitions, Esports Federation do not act as event organizers, and as such, esports publishers have exclusive right to organize them based on their intellectual property rights. This point is very huge difference between the esports society and sports society. So that's why I want to say that sports lawyers should not misunderstand this huge difference between the esports society and sports society. We cannot apply the same rule of the sports society to esports society because of this aspect. So therefore, it can be considered that they originally possess a dominant power over the esports competition and the intellectual property rights. So in this context, how can esports publishers and esports league organizers govern esports companies' organized competition? This figure illustrates the relationship with various entities, including esports participants, players, organizations, teams, etc., streaming platform providers, platform service providers, or video game distributors, television and media, and sponsorship companies, etc. Each relationship is governed by the bilateral contract with the esports publishers, allowing them to decide how entities can participate in esports competitions based on the regulations and rules. Esports publisher may also impose disciplinary sanctions such as fines, suspensions, or permanent bans on esports players who violate the regulation rules before, during, and after esports competitions. More importantly, this situation allows esports publishers and esports event league organizer to have different policies for each esports competition they organize. As a result, governance of esports competitions can be considered fragmented, as there is no central governing body to establish uniform regulatory framework applicable to all esports competition. In this context, esports federations cannot regulate the activities of esports publishers without a licensing contract, as esports publishers' activities are protected by their exclusive intellectual property rights. This leads to the question of how to understand fragmentation of esports society under the law. Okay, so let's move on to the Esports Federation and esports competition. So in contrast to esports company organized competitions, International Esports Federation may hold international esports competition such as the ISF Esports World Championships and Global Esports Games, only if they have entered into a license contract with esports publishers to use their video games as officially sanctioned esports in the competition. For instance, ISF World Championship 2024 was held in Riyadh, Saudi Arabia on 11 to 19 November 2024. It used Counter-Strike 2, Dota 2, PUBG Mobile, and Mobile League's Legends Bang Bang. Furthermore, GF also held the Global Esports Games on 12 to 16 December 2023, but unfortunately I couldn't find any information for the 2024 version. In order to use these video games in the Esports Federation's organized competitions, ISF, GF must first enter into an event licensing contract with each esports publishers to use them in the competition. So if not, they cannot use the different types of the video esports titles as a competition. So that's why they need to have an agreement to use the esports title in their tournaments, and then they can organize events under the Esports Federation's name. So it means that if not, the Esports Federation have no any power to organize any events. It's not like Sports Society, Sports Federation have the rights to organize anything, all of the, the sports tournaments, but for the Esports Society, the Esports Federation have no any rights to organize any events without a licensing contract. So in light of this situation, this figure clearly depicts the structure of Esports Federations organized competition. Once the event licensing contract is signed between the Esports Federations, Esports publishers, the Esports Federation can establish regulations and rules applicable to all esports participants and business enterprises in the esports competitions. For example, when the esports player participates in GEG, they are bound by GF Constitution and GF Code of Conduct. Furthermore, ISF recently decided to create the anti-doping regulations in the collaboration with the World Anti-Doping Agencies. So it means that they decided to refer to the WADA doping list for the ISF World Championships. And also, ISF decided to refer the dispute to the Code of Arbitration for Sports, but it's really unclear how they can do that because of the political questions of whether the esports are sports or not. So failure to comply with these regulations may result in the disqualification from the GEG. Thus, the regulations and rules established by esports federations may require esports participants and business enterprises in competitions to fulfill certain responsibilities or obligations. Therefore, it is apparent that esports federations can play a crucial role in governing esports competitions through their regulation and rules. You can find these figures, and there are so many entities can be connected with the esports publishers and esports federations, and then not only the esports stakeholders, but also the state authorities, betting companies also involved, and the esports stakeholders can also come to the esports events. There's so many actors can be involved in esports competitions. It's like the sports, that aspect is like the sports events, but still difference because the esports publisher had the dominant power. The esports federation cannot, cannot make the dominant power to control over the esports competitions. And then let's move on to the integrity issues in esports. Integrity issues have been a persistent problem in esports. It's a really famous topic as well. Similarly, the esports society faces the challenges, although it remains unclear what specific integrity issues exist within this esports. So that also, please do not consider that esports integrity is quite similar with the sports integrity. I already saw a lot of initiative taken by the sports world for the esports society, but that is completely different because esports is, from my perspective, esports is not sports, so that's why it's really tough to say that there is the similarity. There is also the similarity, but that's also really completely different. So that's why I will talk a little bit on these issues as well. So, Kuze-Guredi, if my pronunciation is correct, classified integrity issues in esports into the following three categories. Technological issues at first, that is the most important thing, such as software and hardware issues, exploitations of in-game bugs, and glitches and server attacks. And B, player issues, doping, match fixing, and disabling, abusing opponents, mostly match fixing, that's the most important aspect. And C, institutional issues, corruption, technicians and officials, and existence sanctions and player protection. In contrast to the Goshal also examine the topic ethics and esports and classify it into the following categories. First, cheating to win. The software cheats and hacks out online attacks and doping. That is most important thing, doping. And second, and cheating to lose, match fixing, and other betting files, as well as structured tournaments manipulation. Based on this understanding, this lecture will propose an alternative categorization for integrity issues in esports, dividing them into the following three categories: corruption, match fixing, and gambling betting, and doping, the use of performance-enhancing substances, and e-doping, electronic doping, which means computer technology-based cheating. Each of these elements is closely interconnected. For example, illegal gambling and betting in esports can lead to other integrity issues, as esports participants may be driven by the potential for substantial monetary gains from such illicit activity. So, however, this lecture will not delve deeply into this issue, as one of the upcoming lectures in the ERN lecture series will focus specifically on the topic of esports integrity. I encourage you to attend that session for the more comprehensive discussion. It is important to note, however, that there are no uniform regulation or rules addressing integrity issues in esports. Each esports stakeholder, such as the publisher, tournament organizer, federation, developed its own regulation applicable to their specific tournaments and operations, further contributing to the fragmented nature of the esports society. So finally, from the legal perspective, identifying how disputes within the esports society can be resolved is crucial. However, determining the appropriate dispute resolution body for esports-related disputes represents significant challenges. This contrasts sharply with the well-established and structured dispute resolution mechanisms in traditional sports, which benefit from hierarchical governance and unified frameworks. So in esports, dispute resolution can be broadly divided into the two dimensions. First, dispute resolution bodies for inside the competition. These handle disputes arising directly within esports tournaments or events, such as rule violations, self-regulation rule violations, and cheating allegations, or dispute between participants. Secondly, dispute resolution body for outside competitions. So these address broader disputes outside the immediate scope of tournaments, such as contractual issues. We can also go to the national courts, intellectual property conflict. That is also, we can also go to the courts in each national level, and also employment-related disputes. I already saw some of the disputes in the United States and the other states as well. So in this lecture, I will provide a brief introduction to these two-dimensional dispute resolution in esports. When it comes to resolving disputes within the esports competitions, several bodies may have jurisdiction, including dispute resolution bodies established by esports publishers, esports integrity commissions, court of arbitration for sports. But in this figure, I already also mentioned SESF, the referee system. These diverse mechanisms reflect the fragmented nature of dispute resolution in esports, with multiple bodies potentially having jurisdiction depending on the nature of the disputes and the structure stakeholders involved. The first example is Riot Games. Riot Games provide a prominent example of an esports publisher taking the steps to establish a dispute resolution mechanism. On 7th November 2024, Riot Games announced the creation of an independent court of arbitration. The dispute resolution for Riot Games Esports EMEA. This tribunal is designed to address and resolve contractual financial disputes arising in the professional and semi-professional leagues within the EMEA region. The LOL esports, Valorant esports communities fall under the jurisdiction of Riot Games Esports Tribunal, but I already saw some of the persons who already announced as arbitrators before this tribunal, but they are mostly sports lawyers. So that's why I doubted that's how they can resolve the disputes from the sports law perspective, because as I already explained in this lecture, the sports society is quite different from the esports society, and we cannot apply the same rule to the esports society as a whole. So I have to see how they can solve the problems within the esports. And then the second example is the Esports Integrity Commission, ESIC, which was established in 2016 to take responsibility for disruption prevention, investigation, and prosecution of all forms of cheating in esports, including but not limited to match manipulations and doping. ESIC is competent to have jurisdiction over ESIC's members only, and it can handle breach reports investigating the violation of its integrity program. It also has the authority to impose disciplinary sanctions on individuals or entities found to have breached its rules, but addressing issues such as match fixing, cheating, and doping, ESIC plays a pivotal role in maintaining fairness and integrity within the esports society, acting as an independent regulatory body for key ethical integrity-related disputes. At the same time, ESIC has a limited number of agreements with the publishers and also esports federations and also other companies. So it means that the ESIC has no the comprehensive power to control the integrity issues within the esports society. But it is important to know that ESIC try to promote the prevention of integrity issues, integrity violations in the esports. So that is the first initiative taken by the ESIC to prevent the cheating, prevent the doping, and also match fixing. So that is a really important thing within the esports society. We need to recognize that there are great works to promote this activity to improve the integrity of esports. And the third example is the Court of Arbitration for Sports, which traditionally hears sports-related disputes. So the ISF has decided to refer disputes arising from its operations to the CAS for resolution. Additionally, there has been at least one recorded case in which the CAS rendered an arbitral word involving esports. Bahrain Esports Federation filed an appeal against the referring decision before the CAS. However, it remains unclear how the CAS approaches and resolve esports-related disputes given the unique complexity of esports society, and also CAS arbitrator have no any person who knows the esports as well. I strongly disagree with this initiative, as esports is highly fragmented and distinct from the traditional esports society. As I have explained in this lecture, applying the same principles and frameworks of esports sports law to the esports society overlooks the significant differences between the two domains and fail to address the nuanced needs of esports stakeholders. So for disputes arising outside the scope of competition, the primary focus is on issues such as intellectual property rights. So for example, the Varna WIPO has began promoting its WIPO alternative dispute resolution framework to handle IP disputes within the esports industry. In addition to specialized bodies like WIPO, national courts can adjudicate esports-related disputes, including those involving the IP rights, employment relationships, anti-competitive agreements, and discriminatory practices such as gender discrimination. I already showed some of the cases in the United States against the Riot Games presidents, I mean the game companies presidents, and then because of the sexual harassment or the gender discrimination. So if my memory is correct. So in accordance with each country's domestic legislation. Furthermore, international courts like the Court of Justice of the European Union, CJU, and the European Court of Human Rights may also have jurisdiction in certain cases, depending on the nature of disputes and legal frameworks involved. This highlights that dispute resolution bodies for issues outside the competitions typically rely on the national, international, supranational law to resolve esports-related disputes, offering a more traditional legal approach compared to the mechanisms used for resolving disputes within the competitions. As I already mentioned in this, section 9, dispute resolution in esports, there are so many, dispute resolution body, and then we don't know where we should go to, we should use, which dispute resolution body we should use in order to solve the problems within the esports society. That's also the part of fragmentations within the esports society. And then because of this, it's really tough to identify the body of law for the the body of esports law to govern the esports society. So we need to identify how we can categorize the esports society in order to see where is the esports law, and then we can create how we can have the common understanding of esports society from the legal perspective. So that's the end of my lecture. And then if you want to know my informations and also the research, you can follow my LinkedIn and X and OEC ID because I regularly update my research update on the SNS and internet website. So that's why you can follow if you want. And then I also work for the Esports Federation in Switzerland. I sometimes take an initiative to protect the human rights within the Swiss Esports Society. So you can follow our colleagues' works as well, because Swiss Esports Federation tries to do a lot of really good works. And then one of the most organized, the federations within the Esports Society as well. So that's why I recommend you to follow the SESF activities as well. At the same time, as I already mentioned in this lecture, it's really tough to follow the body of law for the esports. So, but that is like the beginning of the stage to establish the esports law. So that's why I really I try to make an effort to identify how we can establish the body of law for the esports society, and then if I can improve the esports society from the legal perspective, that's going to be nice. So this lecture is the part of this my the purpose and objective in my research life. So thank you so much for coming to the episode 1 of my of the ERN lecture series provided by me. So I really appreciate for your participation, and then I hope we're gonna see you soon again. Thank you so much.